Up the case of Page versus Deutsche Bank Trust Company Americas. Counsel for the petitioner, please proceed.
Thank you. Good morning. May it please the court. Nicole Moskowitz on behalf of petitioner Terri Page. We're here today because the Fourth DCA has said that if a borrower gets a foreclosure case dismissed for lack of standing, she can never get her attorney's fees. This is an overly broad, bright line rule that ignores important facts and leads to inequitable results. Let's first look at the facts of this case. It's undisputed that at the time of trial, respondent had standing. Not only were they literally holding the endorsed note and were holders of the note, but by virtue of that fact, the mortgage which follows the note came to be, and the respondent was a party to that mortgage. Also, it's undisputed that in 2017, the respondent filed a new foreclosure action with the same note, the same mortgage, same defendant, claiming to be a holder of the note and also asking for attorney's fees. And the entire time that that case has been pending, they've been claiming in this lawsuit that Ms. Page is not entitled to attorney's fees based on that same mortgage. It would defy reason and credibility if the respondent were to stand in front of you today and say that at either of these times there was no standing and that there was no contract. It's also noteworthy to point out that in the Page opinion, the Fourth said two different times in the opinion that there was standing at trial. Now, the Fourth boiled down its holding to a simple equation in all capital letters.
I'm sorry to interrupt you. So does your position depend on that aspect of this, that there was standing found at trial?
Well, my position is...
Would we be in a different situation?
I'm sorry, I missed the first part of what you said.
If standing hadn't been established by then, would we be in a different situation?
No, my position is that you don't need standing to have a contract. I think the fact here, though, that there was standing at the time of trial, and because it was by virtue of the endorsed note, and since the mortgage follows the note, both parties were a party to the mortgage contract.
Do you agree that it has to have been established that both parties in the lawsuit were actually parties to the contract?
Yes. And being a party to the contract is a separate issue as to whether or not they're standing.
Right. Okay.
And the Fourth boiled down its holding to a simple equation in all capital letters that no standing equals no attorney's fees. And they're improperly equating the lack of standing to the non-existence of a contract. However, standing is much more complex than that. And Harris said it, quote, "The trust's failure to prove standing turned on the very specific proof requirements involved in foreclosure law." And this goes to why standing is different than the formation of a contract. Because when you look at standing in the context of foreclosures, there's rules that you probably don't see in other causes of action. First of all, even though standing is an affirmative defense, it actually becomes part of the plaintiff's prima facie case. They have to allege the basis upon which they're enforcing the note in the complaint, and that has to be proved at trial. And proof of standing...
Well, you know, when we talk about standing here, really the question is about whether the plaintiff has adequately proved standing. Isn't that the question?
Well, right. I mean, well, yeah, they have to prove standing as part of their prima facie.
I think that's consistent with your position. This is about, you know, they may actually be in a position where where the facts are such that they could establish standing, but if they bumble and just don't do it, that's on them, right?
Exactly, Your Honor. You know, a lot of times, look, statute 673.3011 gives you three different ways to allege the basis to enforce a note. You could say that you're a holder when in actuality you're a non-holder with the rights of one, but if you allege that you were a holder, you lose the case. It doesn't mean, you know, that there was no contract, especially when at the end of the day, the banks have been receiving the benefits of having the mortgage, or the plaintiff had received the benefits of having that. And
okay,
also,
can you focus on the text of the statute? Because it seems like the standing stuff, to borrow a phrase from the Fourth DCA, it is a little bit of a rabbit hole. I mean, I think the question for us is, how does what was going on here fit in with the statute?
Well, Okay, so the text of 571057 states, if a contract contains a provision allowing attorney's fees to a party when he or she is required to take any action to enforce the contract, the court may also allow reasonable attorney's fees to the other party when that party prevails in any action, whether as plaintiff or defendant with respect to the contract. Now, what word don't we see in Section 7? We don't see the word standing. What the Fourth has done is they've interjected this extra requirement of standing into what's plainly not written into the language.
So, counsel, is your position that the any action taken here can include filing, cannot include filing a lawsuit where the defendant, or I'm sorry, where the plaintiff doesn't have standing, even if standing is developed later, even if evidence of standing is developed later? In other words, what is any action in plain terms of the statute? What suffices as any action?
Well, this I think it's just what it is. I think filing a lawsuit, whether or not they win or lose, that's any action. I think before a lawsuit is filed, if you request a payoff letter, sometimes you'll see an attorney's fees because they had to, I don't know, run title or do something else, or, get a certain letter. So any action with respect to the contract, but the fact that there's no standing doesn't have to do with whether or not they're parties to the mortgage contract.
Counsel, I'm sorry, go ahead. No,
I'm sorry, Chief. I just wanted to make sure I understand. So then it's your position then that if a party were to take even the action of filing or not filing, sending some sort of demand letter, that would constitute an action for the purposes of 571057.
Well, I guess since when you look at the language, it talks about prevailing party attorney's fees, you do ultimately have to have a lawsuit in which you prevail. So
any action there refers to an action like a lawsuit.
Yes.
Okay.
Well, no, but I mean, the contract, the first clause of the statute requires you to look at the contract and what the contract says. And that has nothing to do with what actually then happens, right? I mean, the second part of the statute is, okay, now there's been a lawsuit and what do we do? But in terms of sort of the trigger for the possibility of reciprocal attorney's fees, you just look at the words of the contract. Does the contract give one party or any party the right to fees if they have to take any action? And that any action could be a lawsuit, it could be writing a letter, it could be to enforce the contract, right? I mean, isn't that what the statute says?
Well, yes, that's what it says, but I think you can't just look at the first part.
We just look for the first part, we look at the contract. And it seems like the question for the first part would be, are both of these entities here that we're dealing with parties to this contract?
Yes, I agree with you. And I think the Harris case gives it a sort of different point of view than Page, because in Harris, they talk a lot about the assignment of mortgage. And by virtue of just the assignment of mortgage, the parties became parties to the mortgage contract itself. And it's important to remember that the mortgage contract, A, that's where the fees are. B, it has, it's a separate document that you could become a party of just because you don't prove the negotiability of the note. The mortgage itself, there could be different parties. For example, a non-borrowing spouse would sign a mortgage, but not the note. And that spouse would be entitled to fees under only the mortgage contract. It also has the conditions precedent of paragraph 22, which is also where the fees are found. So the mortgage contract on its own provides for fees, and there are other ways besides, like in Page, where you have an endorsed note to become parties to the mortgage contract. You can see in Harris that by virtue of an assignment of mortgage, you could become a party to the contract. And to that end, as I discussed in the brief, all that Section 7 requires is a contract that provides for prevailing party attorney's fees, that both the movement and opponent are parties to the contract, and that the movement prevailed. None of this is up for debate in this case. And as I stated earlier, when you look at the very important facts, it's obvious that there was a contract. When the bank's witness was literally holding the endorsed note, endorsed to Deutsche Bank in its hand, they became a party to the mortgage contract by virtue of that. And Ms. Page is entitled to attorney's fees under that contract. Now, I know that respondent brought up in his brief that you need to look to the substance of the litigation, but the substance of the litigation doesn't just stop when you get to standing. You have to look at the complete substance of the litigation, which would be all the facts, and which would be when the judge that day of trial, recognized that the endorsed note was in the record as of 2012, recognized that it was in court, and she even made a comment, well, this doesn't make your argument with respect to standing as strong, but because they didn't have the note on the day that they filed the complaint, there's no standing and the case is dismissed.
Well, and again, to get back to the words of the statute, the question is, was it an action with respect to the contract, right?
Yes, but I mean, there's no question.
Okay, so, and I'm not disagreeing with you. I'm just trying to kind of understand the textual part of this. So what is it that made this an action with respect to the contract? I mean, it's not a trick question. I mean,
right. Are you saying that if there was no standing, then how could it be?
No, I'm not saying, I mean, you're the
Okay.
one making the argument. I'm just asking you a question. The statute requires this to have been an action with respect to the contract, right? And so
Right. Well,
you just need to say, well, how was it an action with respect to the contract?
okay. Well, because it's a mortgage foreclosure. They weren't suing just on the note. They were suing to foreclose the actual mortgage. And it's the mortgage that is the security agreement and that allows them to foreclose. So I believe that's how it was an action on the contract. Also, they were seeking all the amounts due pursuant to the note. So no matter how
hard, it would be hard to think of an action that would be more with respect to the contract than a mortgage foreclosure. I mean, I don't know what possibly could be. Can you think of one, counsel?
where, I mean, the whole cause of action is created from the contract. I suppose you could have an equitable lien where it's not, but even that's usually based on some sort of contract or something that happened.
Ms. Moskowitz, if I could ask, and I'm going to ask you to sort of step back away from the attorney's fees issue and look more fundamentally at the standing requirement and 702.0152. And do I understand correctly that that statute has been interpreted to mean that if the plaintiff's allegations regarding its right to pursue the foreclosure are inaccurate, that even if they do have the right and they amend the pleadings and prove that right at trial, it's still a dismissal because their initial allegations were incorrect?
Well, I've seen cases where they've improperly alleged their status to pursue the note. And if there's been problems with the verification of possession of the note, I don't necessarily think that in and of itself will get the case dismissed, and especially if they've amended their complaint at some point. But I do think that and Rule 1.115, which requires verification of possession of the note, it doesn't really have any teeth if there's no consequences. Because at the end of the day, the bank, if they lose a case, they don't really lose anything in these foreclosures.
But I'm looking at why they lose the case and if it makes sense. I mean, it seems to me in any other context, so you sue on a contract, and our pleading requirements say that you have to allege that you're a party to the contract and you have to attach the contract. And it is not infrequent that some lawsuit is filed and the contract is not attached. But that pleading defect is curable. And so there would be a motion to dismiss or filed, and then instead of actually dismissing the case, usually the party would say, well, I need leave to amend, and leave to amend is freely granted. And then we go forward with the lawsuit. And even where the pleadings are wrong and we go all the way through trial, if there's no prejudice, in every other context, we allow the pleadings to be amended to conform to the evidence so that the case can actually be decided on the merits. And so I'm wondering what in the text of the statute makes this different.
Standing, as I was saying before, under foreclosure cases is just a different beast than in other causes of action.
What's the statutory basis for treating it from other allegations?
Well, I think that the case law has said that it becomes part of plaintiff's prima facie burden.
So what's the legal basis for that under the statute? Because foreclosure is all statutory.
True. Well, if you have to allege your basis to enforce the note, then it becomes part of your burden of proof.
Right, but
It
you
becomes
have
what you
to
have to
allege a
prove.
lot of things in a lot of different contexts, but if you get the allegation wrong, you can amend anytime, including to the end of trial in most instances. So what's the statutory basis? Because it seems to me that that's really the problem, is that in the end, you have a case where the original allegations don't line up with the proof, and there's no opportunity to cure it at any point. And so you end up in the circumstance where you should have a right to attorney's fees, but because the original allegation wasn't quite correct, then there's an argument that you don't. So why aren't we looking at what the statute says, which is that you have to make an allegation, not that you actually have to, that it has to be correct. So why I mean, you understand?
The reality
I
is
think you
that
understand my
I'm
question,
sorry.
Virgil.
Yeah, I mean, I think the reality is that a lot of times, and I've done only do foreclosure law, is that the plaintiffs don't move to amend. They proceed on being a holder or being whatever they've alleged and stick to their guns. You know, I mean, they did in this case. Nothing changed. And
But
when you don't
under
have
the
that
law
situation,
as it exists, whether they sought to amend or not wouldn't make any difference, right? Because if I understand the law that's established, and is really, which is not an issue in this case, is that if you don't have standing when you filed, you lose.
yes,
Is that correct? Now that, and I mean, I can understand that there are questions about the appropriateness of that rule of law. Okay, I've got questions about that myself, but that's not really an issue in this case. Correct?
agreed. No, we're past that point, because here, you know, nobody did try to amend the complaint, and we're left with the facts of what they are. And the plaintiff can't just disavow those facts to meet his position, saying that we're not entitled to attorney's fees. Because going back to the certification, if there's no consequence and plaintiffs can just keep refiling, then you're just, you know, going down this endless rabbit hole where there's nothing to stop them.
Counsel, you're now into your rebuttal time. So you can keep going, but you're consuming rebuttal time.
I'll reserve my time. Thank you.
Counsel?
Good morning, Mr. Chief Justice. May it please the court, Will Grimsley on behalf of the respondent. There are three primary reasons why this court should approve of the Fourth District's decision Page. One, as the court has been discussing, the plain, unambiguous language of the statute. Two, the equitable arena within which foreclosure cases exist. And three, the fundamental concept of jurisdiction. Now, I'd like to
help me understand what the unambiguous language of the statute you're talking about.
Sure. Let me break the statute down for you. The statute provides that if there's one, a contract that provides for fees, two, that fee provision allows fees to one party when that party enforces the contract, then three, the court may allow fees to the other side when that other side prevails. And so the critical language in the statute is action to enforce the contract, to enforce the contract. So to trigger reciprocity under the statute, you have to first be a party to the contract. And two, you have to have the ability to get fees for enforcing the contract. So stated another way, when the other party can only get fees if the first party can get fees for enforcing the contract.
And
So-
counsel, sorry to interrupt you.
That's
Do you agree that though that determination is made just from reading the four corners of the contract before anything happens with an actual enforcement action?
The particular part of the statute that requires a provision that provides fees for taking
Any action to
enforce a contract is within the contract, and we have that here. Our mortgage.
So you agree that that part is satisfied, and you agree that both of these parties are parties to the contract?
I would agree that at the time of trial, the evidence in the record reflects that both parties were parties to the contract, but it's a different analysis for purposes of 57-105, because what the court determined was that the plaintiff could not enforce the contract, could not enforce the note and mortgage. So,
well, that's because you didn't prove what you needed to prove concerning your standing at the inception of the lawsuit. Isn't that correct?
Well,
that doesn't change what's in the contract.
It doesn't change what is in the contract, but it's an adjudication that the plaintiff is not entitled to enforce the contract at the beginning of the case. And now
but again, the first sentence of that statute is not about whether you at a particular point in time are entitled to do anything. It's about what the contract says. And I mean, I think we agree on that. I mean, I've heard agreement on that, but then I see the analysis kind of shifts away from that fundamental point.
Because the party has to have the ability to enforce the contract to get fees. And what we have here is a party, the plaintiff, who was determined not to have the ability to enforce the contract. Because the plaintiff did not have the ability to enforce the contract, the plaintiff does not have the ability to get attorney's fees for enforcing the contract. Because the plaintiff did not have the ability to get attorney's fees for enforcing the contract, there's no reciprocity. And because there's no reciprocity, the defendant in this case would not be entitled to fees.
But I don't understand how there's a lack of reciprocity just because one side loses because they failed to make their case. I cannot follow that line of reasoning.
So standing is an affirmative defense that must be raised by a defendant or waived. The basic elements of a foreclosure case is to prove a valid contract, a default, acceleration, and damages. The standing, which petitioner recognizes in the briefs, is a defense that must be raised. And what does it mean to have standing? 673-3011 gives us that definition. That defines a person entitled to enforce the contract. Every foreclosing plaintiff must satisfy 673-3011, one of those subsections, in order to proceed in its case. That is why standing is so significant to the analysis here for reciprocity. If it is determined that the plaintiff does not satisfy 673-3011, then the plaintiff is not entitled to enforce the note. So when a defendant prevails on a defense of standing, in a specific defense of standing at inception of the case, then the defendant has the burden under 57-1057 at a separate entitlement hearing to establish that, one, both parties are parties to the contract. And this is the important one. Number two, that the plaintiff can get fees for enforcing the contract. Now, the plaintiff...
that is not in the statute.
Right.
Where is that in the statute, counsel?
Part of the statute...
Where?
The part of the statute that says action to enforce the contract. If you can't enforce the contract, you can't get fees.
But that, again, you have agreed, I thought, that when we look at that provision of the statute, that requires us to look at the text of the contract, not what happens subsequently, but what the contract says. And so I'm kind of baffled by your argument and shifting away from that, what you've already agreed to.
No, I agree that the language of the contract provides for fees for the party to, when enforcing the contract. The problem here in our position here is the court said, we can't enforce the contract. If we can't enforce the contract, then we can't get fees.
Okay,
and so,
counsel, can I ask you a question?
Sure.
Is there a difference when a defendant says there's no standing because the plaintiff didn't comply with the statutory requirement to do X, Y, or Z versus saying there's no standing because there is no contract between us?
If I understand Your Honor's question, a particular statute or foreclosure statute?
Well, I mean, it seems like if I'm focusing on 57-105, your argument would be more attractive if a defendant is saying there is no contract between us and therefore there's no standing, and then turning around and saying, oh, under the contract that I said we weren't both parties to, I now want attorney's fees. But that doesn't seem like that's what's going on in this particular context because of these pleading requirements, where because of the unique arena that we're dealing in, this concept of having standing and proving standing in your initial allegations or proof, at the beginning of the lawsuit, that doesn't require the defendant to say that there is no contract.
And so I'll just note that this is a 2009 case, which predates the implementation of verification, all those pleading requirements. And that's just to note. But by taking the position that a plaintiff doesn't have standing at the beginning of the case, as the petitioner did in this case, that the plaintiff is not entitled to enforce the note at the beginning of the case, the defendant is necessarily taking the position that the plaintiff is not a party to the contract. If the plaintiff were a party to the contract, then the plaintiff could unquestionably enforce the contract as a party to the contract. But that's not what the petitioner or the petitioner did here. And so standing, as the petitioner concedes in the brief, standing is something that cannot be cured post-filing. So if you have a failure of standing at the beginning of the case, then that can't be cured within the four corners of this case. That is an adjudicated fact that the court makes that lasts the entirety of the case. Sure, a plaintiff can refile another case. The plaintiff can then establish standing in another case and invoke the court's jurisdiction at that point. But within the four corners of this particular case, it has been adjudicated that the plaintiff is not entitled to enforce the note. It may appear at trial that the plaintiff is a party to that note, but because of the finding,
but counsel, I mean, I understand. I think I understand what you're saying, but the reality here is that the bank drags the borrower into court, and maybe if the bank did what it was supposed to do, the bank would win. But the reality is the bank drags the borrower into court and the bank doesn't have its ducks in a row. It can't prove what it needs to prove. And therefore, the borrower has been just dragged into court in this failed attempt by the bank. And I'm having trouble seeing anything, any reason why that the borrower is not in those circumstances the prevailing party under 57-105, and it's established in the litigation that and it's undeniable that both parties, both the bank and the borrower, were parties to this contract. And so I'm just having trouble understanding why. Because the reality is the bank brought this on itself, and why the bank, having brought about this, and again, I understand there are complicated reasons why all these things happen, and these are it's a big industry and all that, but having brought this about, why the bank shouldn't have to pay up to the prevailing party.
And the defendant has been, quote, dragged into the court because of a failure to pay the mortgage payments. But again,
I think I indicated that. But then they've been dragged into this failed procedure, this failed lawsuit, because the bank didn't do what it was supposed to do. Isn't that correct?
There was a defense that was established, and so because that defense was established, the defendant obtained a dismissal. But because of the decision of the court, the adjudication of the trial court, that the plaintiff was not entitled to enforce at the beginning of the case, that is throughout the case. The fact is established that the bank cannot enforce this note within this case. They cannot amend. Typically, amending relates back to the initial pleadings. With foreclosure cases and standing, it does not amend back, which taps into the jurisdictional argument we made. And it's a threshold question that is appropriate for this court to make. Even though the Fourth District noted that it didn't address that issue, here, standing in foreclosure cases has become jurisdictional. It is a perfect example that was made earlier that you cannot cure standing by amendment when typically in cases you could. And so why that is, why this argument is so important here is rooted in law from this court, the Lovett case, the Roberts case, and the Byron case. Their subject matter jurisdiction is the inherent authority to adjudicate a certain class of cases. But there is a component of subject matter jurisdiction that this court talks about in Lovett that is missing here, and that's jurisdiction over the parties. In order for the jurisdiction of the court to be lawfully invoked, it has to have the proper and necessary parties. So,
I'm sorry to interrupt you.
Sure.
So do you agree that this was an action with respect to the contract for purposes of the second part?
I would agree that this is an action with respect to the contract, but I would submit that it is that the plaintiff cannot enforce the contract because of the finding of the court. Because the plaintiff cannot enforce the contract, it is not an action enforcing the contract that would entitle this foreclosure plaintiff in this case to get fees. And because this foreclosure plaintiff in this case could not get fees, then the reciprocity provision under 57105(7) is not triggered.
So for you to win, we would have to agree with your interpretation of the first clause of this statute here. Not the second clause, you agree that this is an action with respect to the contract.
It is an attempted action, yes, Your Honor, but the failure here under the statute is the ability to enforce the contract. And under the second point we make in our brief, this taps into the equitable nature of foreclosure proceedings. And standing again is an affirmative defense, and when that when a defendant prevails on an affirmative defense of standing at inception, the defendant can't take a contrary, inconsistent position later in the case. That is the doctrine of estoppel against inconsistent positions. Under that doctrine, a plaintiff who gains a dismissal by first asserting the bank has no standing to enforce the note cannot gain more, i.e. attorney's fees, by asserting a second inconsistent position, that is, plaintiff is entitled to enforce the note later in the case that the plaintiff or that the defendant couldn't have maintained under the first position. And that's exactly what we have here. That's the equitable problem here, is you've got a defendant on the one hand saying you can't enforce this contract, but on the other hand, at the end of the case, stating that, yes, you can enforce this contract, and the doctrine against of estoppel against inconsistent positions.
Counsel, it seems like their position may be that you cannot enforce the contract in this case because you didn't make the appropriate pleadings at the outset. Not that you can never enforce the contract because you're not parties to the contract, but you lose in this case. It seems like the interpretation that you want to present and ask us to adopt turns 57.1057 on its head, because the bank has a contract that provides for attorney fees to the bank, not to the borrower, but by virtue of the statute, it gives them attorney's fees. But it seems like your interpretation will award fees to the borrower only if the bank is able to win. And that gets you right back to the original position that the bank had without the statute.
And the position here does not interfere with the legislative intent of the statute of leveling the field. It just requires that the language of the statute that we submit is the one party who has the rights under the contract has to have the ability to enforce that. And in this case, now in another case, perhaps the bank can enforce it, but within this case, once it is established, once the court has adjudicated that the bank doesn't have standing, i.e. doesn't have the ability to enforce the contract, then that's stuck for the rest of the case, and including an entitlement hearing at the end of the case. And that goes back to the jurisdictional problem the courts or the plaintiffs faces. You can't fix it without filing a new case. And if you can't fix it because it's jurisdictional, that means that you never had the proper key to the courthouse. You never had the proper key to start the ignition of the court. And therefore, the court had to remain at rest once it determined there was no jurisdiction. And because the court had to remain at rest until the proper party invoked its jurisdiction in a separate lawsuit, it could not have awarded independently a fee judgment as the judge did in this case.
Well, now in this case, I mean, you're characterizing what the court did as determining it had no jurisdiction. The court never actually said that.
The court never did say that, correct, Your Honor. But
yeah, that's your characterization, and it's I mean, I understand what you're arguing, but that's not that's your gloss on what the court did.
That is, but a finding of standing is results. First of all, it can't be cured. It results in dismissal, so it has to be jurisdictional. There are cases out there that have described standing in foreclosure cases as jurisdictional, and standing, as in the Lovett case, described as you have to be the proper party, necessary party to invoke the court's jurisdiction, and until that proper party invokes it.
Well, the court has jurisdiction, even the jurisdiction is not equivalent to standing. In our
But without
law.
standing, but the jurisdiction of the court has to be triggered by the proper party. And when the proper party doesn't, when the court says this is not the proper party because you can't enforce this note, you must dismiss the case, then the jurisdiction hasn't been invoked. So the plain language of the contract, Your Honor, does provide for fees when a party has to enforce the contract. The problem there under the statute is that the party has to have the ability to enforce the contract.
But it seems like, I mean, it seems like by conceding the first part of what you just said, and by conceding that this was an action with respect to the contract, you've basically conceded that the petitioner here should win.
No, Your Honor, our concession is simply recognizing that there's language in the contract that provides fees to a party for enforcing the contract. Our position is that because the court adjudicated the fact that this particular plaintiff cannot enforce the contract, then that particular plaintiff cannot get fees pursuant to the contract. Because that plaintiff cannot get fees to the contract, 571057 is not triggered, and therefore there's no reciprocity. So when factoring in the plain language as we have submitted to the court, the equitable nature here and the doctrine against inconsistent positions, and then of course the jurisdictional concept, the court should approve the decision of the Fourth District. If there are no further questions from the panel, then we would ask the court to approve the decision of the Fourth District. Thank you.
All right, thank you, counsel. Rebuttal argument.
Counsel, can I ask you a quick question? So is there, so when your client in their capacity as a defendant here, when they allege that there was no standing, is that different from saying there is not a contract between us and the plaintiff bank?
Yes. Standing has to do with the negotiability of the note, whether or not they had possession of it the day that they filed the lawsuit, and whether or not it was endorsed. And here the court adjudicated that there was no proof that it was endorsed on the day that the lawsuit was filed.
So if the defendant had argued, hey, there's no contract between us, they've got the wrong person, or this is the wrong bank, or whatever, would that be different? Would that then prevent you from coming around after prevailing on that and saying, oh, by the way, there is a contract and I want fees because of this reciprocal provision?
Yeah, I mean, that's a completely different scenario. And Glass relies upon the HFC case, the Alexander case. And in those cases, there was affirmative proof that there was no contract, or in Alexander, there was an affirmative finding by the court that neither the note nor the mortgage were ever assigned to the plaintiff. That's a different situation. Here, there was an acknowledgement by the court that they had the contract in 2012, and that it didn't make my case as strong. That's not what's at issue in this case. And I think that when counsel's talking about the enforceability of the note, he's ignoring the Katz case from this court that specifically says you're still entitled to attorney's fees even when a contract is found to be unenforceable. And this isn't a case where we're taking an inconsistent position, because standing, as I've explained, is different than the formation of a contract. And like I said, in Harris, you saw the contract being formed by the assignment of mortgage, and the mortgage contract had been assigned to the plaintiff, so they had a contract. And when you look at foreclosure cases, the banks are the ones with all the knowledge. They know where the note is stored, whether or not it's endorsed. They know everything. And when they file a lawsuit, they better have their ducks in a row, as Chief Justice said, because they're the only ones with this information. That's the reason why this court, and there's a statute that you have to verify having possession of the note, was to stop cases from going on and people being dragged into court for 11 years. And when you don't hold their feet to the fire and have any sort of consequence for their failure to prove their case, because standing is part of the plaintiff's prima facie burden, that's what makes it different in foreclosure cases, then there's no consequence. Because like I said, they can just keep filing and filing. Why? It's inequitable not to allow for attorney's fees.
All right, counsel, I think if your time is up, but I'll let you go on for about 30 seconds. You'll just sum up.
Thank you. Just when the Fourth declined to go down the rabbit hole and ignore the facts and ignore the equities, it didn't give this court any basis to make the same determination as the Fourth. And I respectfully ask that this court resolve the conflict in the same manner as the Second and the Fifth. Thank you.
All right. We thank you, counsel. We thank both of you for your arguments in this case today. That's the last case on the docket for this oral argument week. So the court will now stand in recess.
Thank you.